All right, so today I wanted to chat about the 2020 Trademark Modernization Act, how it came about, what exactly it's intending to do, why the need for the Trademark Modernization Act, and some takeaways and how some practice pointers, some things that you can use towards your practice to best help your clients with this new knowledge at hand. So yeah, thank you, Lydia, for the very kind introduction. I am Karima Gulik. I'm a patent and trademark attorney, and I'm the principal attorney at Innovent Law here in Orange County. We help clients protect their patents, their inventions through patents, trademarks and marks, brands through trademarks. So a little overview of what we're going to be discussing today. First of all, why the need for Trademark Modernization Act. And we'll go back to the Lanham Act, the foundation of trademark law in the United States. Why the need for a Trademark Modernization Act? How foreign applicants and applications are frustrating the purpose of the Lanham Act, and some of the best ways to incorporate these changes, the TMA, the Trademark Modernization Act, in your trademark practice moving forward. So as of last year, end of last year, December 27, the trademark law stepped into the modern era and looking to massage and finesse the 74-year-old body of laws known as the Lanham Act into something for the businesses of today. So as of the end of last year, Congress enacted several amendments to the Trademark Act of 1946. That was the last time it saw a facelift. So it was very much overdue, just update and makeover overall. Businesses and the way we do business has changed quite a bit since then. So it was only about time to update some of these laws. And so why the need for Trademark Modernization Act? One of the main purposes is really to remove what the USPTO calls trademark deadwood and fraudulent marks from the United States Patent and Trademark Office Register, the principal register and supplemental registers. And it's while I was preparing for this, I did a little bit of research, and according to NYU professor who testified before the Judiciary Committee, he mentioned that 60% of fraudulent applications for shirts filed successfully proceeded to publication in 2017 alone, and of those, 40% were registered in Class 25. We all know that last year, the Trademark Office has seen a dramatic increase in applications, around 40%, and a lot of those coming from China. And so, yeah, so these were in 2017 alone, 60% fraudulent applications making their way through publication, and of those, around 40% registering and seeing the light of day and just clogging the trademark registers. This was in Class 25 alone for shirts. So for those of you in sports and entertainment services, that just goes to show you how much more fraud there is in the trademark office these days because of some of these foreign applicants. So another reason for the Trademark Modernization Act is to enhance the commercial innovation and bolster integrity of the USPTO process and procedures. And we'll see how the USPTO is going about that and some of these changes to the Lanham Act or the Trademark Modernization Act. But before that, I wanted to go back to one of the main reasons for the Trademark Modernization Act is to make sure that the main purposes of the Lanham Act are fulfilled. So as you know, the Lanham Act, which governs trademark law in the United States, was instituted to protect. So we have words, names, symbol, or devices used to identify and distinguish one's goods from those manufactured or sold by others and to indicate the source of goods. So we're talking word marks for the brand, we're talking slogans, we're talking design applications, so trade dresses, we're also talking about logo applications, stylized marks, sometimes even some of the less common ones, scents, colors, and things like that. So the purpose of the Lanham Act really has two major purposes or two major goals. One is to protect the public, and the second one is to protect the businesses. in protecting the public, the Lanham Act intends to essentially make sure that when a consumer is going and buying something from a brand, that they're getting that quality that they're expected to get from that brand. An example that I like to give is I have some Pilot pens here. Sometimes it's Sharpie, but Pilot pens. So when I go and buy some Pilot pens, I want to make sure that I'm getting the same quality, that it's not just ink inside a felt pen, that is the quality of ink that I expect of this brand. So one is to make sure that consumers are protected. And the second one is to protect a business's investment of energy, time, and money. We all know that businesses spend a lot of time, money, and energy in their marketing, in building a goodwill for their businesses, sometimes in the order of hundreds of millions of dollars to create that brand awareness. So one of the main purposes of the Lanham Act is to also protect that business's investment, and make sure that they're essentially protecting the quality of their work too. In recent events, the Lanham Act, or the goals of the Lanham Act, have been frustrated by a lot of fraudulent applications and just a disproportionate amount coming from China. And we saw that even more last year. Sometimes filing, and by fraudulent, I mean filing for applications when there was never any use in commerce, claiming that there was use in commerce. Sometimes sending photoshopped and digitally altered images to show use in commerce, even though those things have never existed or never were sold in the US in commerce. Just to rewind back a little bit, so as you may know, we have two types of applications in the US. We have the 1A if you're already using the mark in commerce. A 1B is the intent to use, and once you show use of the mark in commerce through that statement of use, you get your mark registered. I'm not talking today about international applications or applications coming from other countries. For those, there is no need to show use in commerce in the United States, so long as they have valid registration in other countries, and so long as there was an actual purpose of filing in those other countries first before coming to the US. So resulting in basically having a packed register, a packed trademark register with a crowded trademark register with some marks that should have never been there in the first place, and some marks that are stopping innovation, stopping businesses from launching and legitimately building brands and building those intellectual property assets in their businesses. So, what does the Trademark Modernization Act do? Congress promises to streamline an otherwise protracted and necessarily expensive process at the USPTO and protect consumers from all these fraudulent and misappropriated marks in the marketplace. I'm going to go back to the chat, but how many of you have seen, I don't know if your clients ever sell through third-party platforms like online retailers, maybe Amazon, Etsy, or anything like that, getting shut down because of a trademark that, when you look into it, is not really a trademark that should have ever been issued. Or maybe you get a 2D or you do your search and you find out that your mark is your clients cannot really register their mark because of a trademark that doesn't really look that doesn't look like it belongs actually on the register. Just by show of hand, and you can drop that in the Q&A if you've had any experiences like that. Many times. Yeah, Kevin, I'm with you. I've seen that, and every time it just makes my blood boil, because it's just not fair. It really isn't fair to the people who are legitimately spending a lot of time, money, and resources to do things the proper way in order for them to build legitimate businesses in the US. So overview of the new law, and we'll go over some of these in details, but the House of Representatives Bill 6196, or the Trademark Modernization Act. So if you're looking to go read it thoroughly, that's the one that you're looking for. And what the new bipartisan legislation aims to do is, one, codify the informal letter of protest trademark process. to allow trademark examining attorneys the flexibility to shorten time as required to respond to trademark office actions. Provide third parties to new procedures or processes to the inevitably expensive TTAB cancellation process. And last but not least, protect business owners' IP by codifying the irreparable harm standard in trademark injunction suits brought before federal court. And we'll go over all of these in more detail. So first, I wanted to talk about the letter of protest. And it's funny. I was at a trademark conference, the Washington in the West, when the USPTO comes out here. And it's a little interesting to see how many trademark attorneys either don't use the letter of protest, that tool, or some don't even know about it. So if you've ever filed a letter of protest, please let me know in the chat. And if you've ever filed one, how successful were you at getting a positive response? If you don't know what a letter of protest is, please let me know, because we'll go over that in details as well. Okay. And Kevin, when you say they were all successful, you mean they were taken into consideration? And was there an office action response, an office action issued based off of those letter of protests? Okay, perfect. That's lucky. So that's great news. So for those of you who don't know what a letter of protest is, it's a letter that a third party can send to the United States Patent and Trademark Office in order for essentially to alert them of an issue with a pending application, with whether it be a descriptive or generic mark, whether that mark is going to be conflicting with prior pending application or a prior registration on the principal. And timing is everything with the letter of protests. So the best time to send these is really either ideally before the application is taken up for examination and the application is assigned to an examining attorney. Or you can do it anytime before it is published for opposition. Those are ideally the best times. So how do you find out about those applications that might be problematic to your clients? Watch reports are one of the greatest tools to be used for that. That's one of the main ways for me to even find out about these. Every time I've done a letter of protest, it was because I set up watch reports for clients' portfolios and found some of these new pending applications that were going to be an issue to clients. A lot of times, also, I will have clients doing their own research, snooping a little bit, and alerting me of someone who is intending to file something. So I kind of look for it as well. So as of last year, there was no fee for the letter of protest. This year, there is a nominal fee or a fee of $50 in order for you to file the letter of protest. What the Trademark Modernization Act promises for letter of protests is codifying them. So before, you would file one and it was up to the discretion of the director, if they ever got around to them, to look at them and determine based on the letter whether there was any substance, whether the letter had any legs, and whether they would take it up for consideration for the application in question. I've never had any issues having the letter not being reviewed on time, mostly because I've always filed it way before, either before it was assigned to an examining attorney or right around that time. So I really think that timing was a little bit of everything. But what the TMA promises is that within 2 months, the petition will be, your letter of protest will be reviewed, and you will get an answer on that letter of protest filed. And this is from the USPTO website, but what a letter of protest is you can use this letter to give the USPTO evidence about the registrability of a trademark in a pending application that belongs to another trademark owner. But you can also do that for descriptiveness or generic issues. A fee is not required for the letter of protests. And there are reasons for filing letter of protests that are considered appropriate reasons. And there are other reasons that are deemed not so appropriate by the United States Patent and Trademark Office. So some of the appropriate reasons that the USPTO deems relevant are in ex parte examinations, or anything that is likely to be confusingly similar with another registered trademark or a pending prior application. Whether the trademark in the protested application is just descriptive or generic for the identified goods and services. Whether the trademark suggests false connection, and this is another one of those rare, refusals, if you will. So how many of you are familiar with suggesting false connection, or have ever gotten a trademark suggesting false connection, or used that maybe for a basis of cancellation? Okay. So some of the inappropriate reasons, or reasons that the USPTO does not deem appropriate for sending out a letter of protest. One of them is protester claims common law prior use of a trademark. So essentially, you have a client who's been using a mark in commerce for a few years, never really registered, has regional rights at best, and now is trying to, file a letter of protest for the USPTO to take into consideration their existence. That's something that's going to be that you're going to have to take that up either on opposition or cancellation at the TTAB. The letter of protest is not the right tool for that, mostly because there's nothing for them to issue any office actions based off of. Whereas if you have a prior pending application, or if you have a registered application, then they can actually issue some sort of office actions based off of something that is that they have leverage over, or something that they can actually use. As you know, you can't get a 2D or likelihood of confusion rejection for something that is common law, related and not in existence on the register or a prior pending application. Another one of these inappropriate reasons is if the protester claims that the applicant is not the owner of the trademark in the protested application. So if you're just a protester saying the applicant is not the real owner of the trademark, that's not something that you're going to have to do with a letter of protest. That's something that you might, look into either opposition given the proper time frame, or maybe cancellation. And the last one is, this is not a tool to be used if you're just disagreeing with the examining attorney's examination of the protested application. So if you just don't agree with something that the examining attorney issued or did not issue in a given application, this is not the tool for that. There are other means, to assert your rights. Letter of protest not being one of them. I love letter of protests. They're an invaluable tool. And until today, they were actually, if you look at on the TMAP on a trademark manual examination procedure, but if you look on the TMAP, it's something right now that was called a tip, and up until recently. Now it's being codified, but it was essentially used as a tool, not as known by most practitioners. So given this undervalued tool, the time of day and having it codified is a step forward for the Lanham Act and for the trademark laws. When to file your letter of protest. So as I said before, I still think the ideal time for filing a letter of protest is any time before it gets assigned to an examining attorney, because really that's when it has the most effectiveness. You want to bring to the attention of the examining attorney anything that you deem relevant, whether it be genericness, whether it be descriptiveness, whether it be likelihood of confusion for either a prior issued application or for a prior pending application. So ideally before the trademark is published for opposition by third parties, and I personally say ideally before it's assigned to a trademark examining attorney, but you have up and before publication to do that. So letter of protest filed before publication must include evidence that it is relevant to the stated reasons that you're basically wanting to refuse registration or issue a requirement. Letters of protest filed after publication must include evidence that establish a prima facie case for refusing registration or issuing a requirement based on the stated reasons, the ones that I just mentioned earlier. So descriptiveness, genericness, likelihood of confusion, suggestion, false connection, and yeah. So this is a little bit about, about the letter of protests, and it's really an inexpensive alternative rather than having to spend $600 per class on canceling someone's mark or opposing someone's mark, again, per class, not to mention how long these proceedings take. So for some of you in the audience, how long would you say it would take to oppose like a regular average opposition or cancellation proceeding? I'd love to see what your experience has been or what your guesses are. Okay, 1 to 3 years. Yeah, and that's actually about the average. That's what the USPTO, after doing some digging, that's exactly what they say. The average being around 3 years, and that's a lot of time and money to be spent. So if you can avoid it altogether and send a letter of protest, do so. Next, flexible office action response times. And just bear in mind, and this is applicable to the entire context of today's presentation, but the act passed at the end of last year, and the United States Patent and Trademark Office has until the December of this year to basically for it to take full effect. So a lot of things we don't really have clear answers on, but we have some sort of guidelines for. So one of them being this, because I did a little bit more digging on flexible office action response times, and I saw some preliminary questions for this. And feel free to drop your questions as we're going through each section. If you have any questions, I'm happy to answer them as we go through the presentation. But flexible office action response times, the Trademark Modernization Act provides that the USPTO now has flexibility in setting times to respond to office actions. And so before the Trademark Modernization Act, all office actions had a pendency of 6 months. So whether it be disclaimers, amendment of identification of goods, or more substantive office actions such as likelihood of confusion, descriptiveness, genericness, or the ones that the Trademark Office has been very happy handing out these days is failure to function as a mark. Before all of these had, regardless of the simplicity or the complexity of the office action, applicants had 6 months to respond. That is not the case anymore. So now the new provision allows for the office. So at the examining attorney's discretion, they can set the period by regulation between 60 days and 6 months, with the options for an applicant to request extensions to a full 6-month period. And there might be a fee for that, most likely. And it's not clear whether you're going to have to pay per month. So I don't know if you're, so at the patent office, you have a shortened statutory period of 3 months up to 6 months, and then you have to pay for each month additionally as you need, if you need additional time. So the Trademark Office might do that. We'll see more. You will have more clarity essentially on this in the few upcoming months. But yeah, so we don't really know as of yet, but it's looking like it is at the discretion of the examining attorney, and you'll have the opportunity to request extensions to a full 6 month. I'm just seeing here. Also, it is not clear whether the 2-month versus 6-month is going to be given based on the complexity of the office action or not. So we'll know more and we'll learn more in the next upcoming months.
I decided to unmute Karima, sorry, instead of typing.
Sure.
We did have a question with regard to the timing, the shortening. significantly. So I was wondering, do you think it's going to negatively impact the applicants? Because oftentimes they take time to find counsel or just generally are delayed and slow. So if they're giving only 60 days, do you think it will have some sort of benefit, or to the it's actually the opposite? It's going to negatively impact them.
You know, just from my personal experience, the clients who wait until the last minute will wait until the last minute, even if they're given a year, not necessarily if they're given a month or two. So it really depends. There was also going to be, you know, that option to maybe buy or just request extension. I don't know exactly whether there's going to be a fee for that at this time. I've done a bit of digging and I haven't seen the answer to that. I mean,
Yeah, it
sometimes
makes
you
sense.
have little disclaimers that, you know, the applicant is not going to fight, or minor amendments to the identification of goods that sit there clogging the trademark office, and sometimes you're suspended behind these and having to wait 6 months before the applicant either responds or not. So I think it'll have mostly a positive impact, you know, by shaking things up and making things, you know, a little bit, expediting things essentially a little bit. But I mean, there's always going to be that, you know, the option to extend the request that extension for a full 6 months, as was the case before.
Okay, thank you. That
Sure.
makes sense.
All right, and now to the cheaper options to challenge inactive marks on the trademark register. All right, so before looking at the TMA, what are some of the current ways to challenge inactive marks on the trademark register? Pop quiz. Exactly, Kevin. Thank you for participating. Yeah, so right now, if a mark is registered, the only way to get rid of it is going through the cancellation. And as you know, those fees went up substantially this year, up to $600 per class, and that's per class. And that's just on the government filing fees, not including any of the attorney's fees, or including how long these things take. And as we saw, it takes about 3 years on average to, for most cases, for a cancellation proceeding. So in order to help with that deadwood that we have on the register, the TMA, or Trademark Modernization Act, is coming up with 2 new creative solutions to help with that. And this was a lot mostly due to the recent increase, like we said, with people sending fake specimens, and mostly cluttering and not having a lot of options for people who legitimately want to build brands. Before the TMA, parties seeking to challenge existing USPTOs could only do so through cancellations, or through filing federally in federal court. Now we have 2 new options. So one of them being a petition to expunge, the second one being a petition for reexamination, and I'll go over some of the details and limitations of each one of them. So the petition to expunge, this applies only to marks that have never been used. So if a mark is on the register, and after some digging, you know, after what the USPTO calls reasonable investigation, you've come to the term that that mark has never been used. They've sent fraudulent specimens. The mark has never been used in commerce. One of the ways to deal with that is that petition to expunge. And so even with these, the cancellations and litigations in the federal courts are still available. But for marks that have never been used, and for US-based applications, one of the ways to go about it is to file a petition to expunge that mark, which has never been used in commerce in the US. How do you go about that is, when you submit a petition to the USPTO, you identify the registration in concern, you identify the goods or services that have never been used, and you have to include a verified statement saying that you've done a reasonable investigation and have deemed that that mark was not in use. Then the USPTO director determines whether the petitioner made that prima facie showing that the mark was actually never used. Yes, sure, may. So yeah, this does not apply to foreign-based applications. As you know, for foreign-based applications, they don't need to have used the mark in commerce in the US. They, as long as they had if it's a foreign entity, as long as they filed abroad, they had a reasonable reason to file abroad first before filing in the United States. As you know, they're allowed, to come in here. This does not apply to that. This, as far as my research goes, this is only for US-based applications, not including any applications that came from other countries. So USPTO director determines if the petitioner made a prima facie case showing that the mark was never used in the US. And if the prima facie showing is made, the director requires registrant to prove use. So this is when the other party gets a chance to either show that for the petition to expunge, they just have to show that the mark has been used. So if they can show use, then no cancellation is issued. If sometimes they don't answer, or if they can't show or prove the use, then the cancellation is issued. Just a note on petitions to expunge, these must be brought between 3 to 10 years, so at least 3 years after the registration of the mark. And that goes, it makes sense for the three, in order to show the non-use for a mark, you have to show the consecutive 3 years of non-use. So these must be brought between 3 to 10 years after the registration date. We'll go over some additional limitations for both the petition for expungement and petition for reexamination. Petition for reexamination, this one applies to marks not used on or before the relevant date. So this is not for something that has never been used in commerce, like the petition for expungement. This is saying that if, for example, an applicant filed a 1A, that they were not using the mark in commerce as of the date of use, as stated in that 1A application, or if it was a 1B, that the applicant did not use that mark in commerce as of the date of filing that statement of use. So relevant date depending on whether it was an intent to use or in use application. Same 4 steps again. We have submission of a petition to the USPTO. Again, you have to identify the registration at issue, which goods or services are challenged for that during this petition. And a verified statement, again, that a reasonable investigation was done and that the mark was not deemed to be in use on or before that relevant date, whether it be the date of filing for the 1A or date of statement of use filing for a 1B application. Again, the USPTO director determines if the petitioner made their prima facie showing that the mark was not in use on or before that relevant date. And if the prima facie showing is made, then the director requires, again, the registrant to prove use on or before the relevant date. So, for example, third party applies and files the petition for reexamination. USPTO looks at it, sees whether the prima facie showing is made. If it's made, then the registrant gets a chance to respond back. For petition for examination, they have to show that the mark was used on or before that relevant date, whether it be the date of filing for the 1As or the date of filing the statement of use for 1B application. If they can show and prove use, then no cancellation is issued. If no use is proven, then cancellation is, if no use is proven, then the cancellation on that mark is issued.
Karima?
Yes.
Can I interrupt?
Sure.
Can you tell us a little bit more about what it means actually to have in the statement that's the reasonable investigation was conducted? Can you give like an example or?
Sure, yeah, and I've done a little bit of research on that too for today's presentation, and it's still vague on that. You just have to make that verified statement. So as long as you've done your proper research to see whether that mark is in use, and I know a lot of us do that too. When we're looking at whether client wants to register a new mark, you're doing your due diligence. One of the things we go through is trying to see whether there is still use of that mark. So for example, one way of going about it, I like to look at the specimen that the applicant used and see if that specimen is still valid, if those trades or channels are still applicable. If it was a website, is that website still live? If they were selling through retailers, are they still selling through retailers? Are they selling anywhere? Is there any presence for them? Is the business still alive? Is the owner of the application still a business entity that hasn't been dissolved yet? A few of those things, but just really doing your due diligence before providing the verified statement. And again, that reasonable investigation. There isn't a whole lot on that quite yet, and I'm sure we'll see more as this gets fleshed out. But yeah, I would assume any sort of reasonable investigation that we would do before going and trying to cancel someone's mark for abandonment per se, or the same standard might apply.
Okay, thank you.
Sure. Another thing, so and then for the petition for reexamination, the timeline on that, this one must be brought within the first 5 years after the trademark is registered. And it's usually generally directed at registrations where there's a questionable specimen. And when it was submitted during examination of the underlying application. Regarding both petition for reexamination and petition for expungements, even though third parties can initiate these, the director can initiate either of these proceedings without third parties, discovering this. So the USPTO and the director of the USPTO can initiate these without necessarily being tipped by a third party, if you will. This reminds me a little bit about the audit program, and I don't know how many of you have gone through the audit program, and I'm happy to go over it a little bit too. If you haven't, but audit, sometimes when a mark is up for renewal or for maintenance, the USPTO might, as you know, when you're renewing or when you're filing something, even if you list 10 items under one class, you only have to prove or show in the specimen one item from those 10 items. So part of the audit, and the USPTO is really part of the audit program because they were able to remove quite a bit of deadwood and things on classifications that should have never existed in the first place, or that shouldn't be kept on the register. But the audit, essentially, they'll pick a few items at random from a given classification and ask for proof of use in commerce. So if it's the goods, the labels on the goods, or if you're selling them online marketplaces by the applicant, showing the marks on the goods. If it's services, then any marketing material for those services. So yeah, petition for expungement, petition for expungement for marks that have never been used, that are registered. Petition for reexaminations, this is for things that have not been used in commerce as of the relevant, on or before the relevant date. And third parties can initiate these, but the USPTO, the director of the USPTO can also initiate any of these without involvement of third parties. So some of the limitations to the expungement and reexamination petitions. One is you can't have co-pending challenges allowed. So you can't have multiple petitions for expungements or multiple petitions for reexaminations co-pending. And the second limitation is estoppels procedures preventing more than one petition against registrants for the same mark and the same goods and services, regardless of the identity of the petitioner. So only one petitioner can file a petition for expungement or a petition for reexamination for a given mark and a given class of goods and services. All right, and last but not least, the Trademark Modernization Act aims to restore the irreparable harm presumption in trademark suits for injunctive relief. So one of the recent Supreme Court ruling in 2006, eBay versus Merck Exchange, United States Supreme Court ruled that an injunction should not be automatically issued based on a finding of patent infringement. And several courts extended this ruling to trademark cases and frustrated the rebuttable presumption of irreparable harm in trademark proceedings. This also left a lot of trademark litigants with little to no choice but to provide evidence in an attempt to satisfy the strict four-part standard for injunction claims. And even though this really seemed like innocuous at first, the practical realities of this next were pretty fatal to many trademark cases. So without the rebuttable presumption of the harm in trademark cases, litigants would have to prove a harm that in the context of trademark law was primarily reputational, which by its very nature cannot be quantified or compensated with mere money. And lastly, the Trademark Modernization Act codified the rebuttable presumption in trademark suits for injunctive relief, effectively restoring a commonplace practice in trademark cases. So with the presumption back in place, parties can take back rightful ownership of their brands and preclude infringers from the marketplace, serving as the sole source of the product and service at issue. And that's it. And I wanted to open it up for a Q&A. So one of the questions that I also got was the 60 days. Is it 60 days or is it 2 months? I don't know. I researched it. I wasn't able to get a clear answer on that. So with a lot of these, as the year progresses, we're going to get a little bit more clarity on a lot of these issues, if you will, too. And maybe that was a good question about the foreign use-based applications, because I was wondering the same thing. And we all know that, it's sometimes not fair, but we're given the same privileges in other nations too, in other countries, for filing trademarks without necessarily showing use there too. And there was a famous case, I was actually digging into this a little bit too, someone filing in order to overcome the use base filed in another country that didn't require use, and then filed in the US. And when trying to assert their rights, their trademark was canceled because it wasn't clear why that applicant chose to file in another country first before coming to the US. It looked like the whole purpose of the application was just to obviate the use requirement here in the US. And it's especially not fair when you see biotech companies having to go through, the entire request of extension of times and still having to lose their priority date and do everything all over again, just to have first use date in commerce.